Good afternoon, everyone. We're going to give everyone a couple minutes to come into the room. I see the numbers start to add up as people are coming in. I'm Lisa Timmons, and we have Robert Raitt. I call him Bobby. So let me just give you a couple minutes for everyone to join us. All right. Got about 15, 20 people here, Bobby. Good afternoon. Welcome. I'm Lisa Timmons. I am the Executive Director of the Mediation Tribunal, and I am the ADR Clerk of Wayne County Circuit Court. In that role, we handle the case evaluation of tort cases for the not only Wayne County Circuit Court, but the U.S. District Court and many of the lower district courts in the County of Wayne. Bobby Raitt, that's here with us today, is our plaintiff representative on our Board of Representatives, but Bobby is also the founder of Raitt Law. He is a personal trial injury lawyer. He's been working in that capacity for decades. He's past president of Michigan Association of Justice and past president of the negligence section of the State Bar of Michigan. Bobby is going to be here representing the plaintiff's bar. We're still waiting on one other person to join us, and that's Tim Brady. Tim represents the defense perspective. He is currently president of Michigan Defense Trial Council. And hopefully Judge Patricia Brizard, our chief judge of Wayne County Circuit Court, will be able to join us too. The reason we're talking about this panel today, as you all know, case evaluation has been the main focus of ADR within the landscape of Wayne County, with the state of Michigan. When I go different places, I refer to it as a funky form of ADR because outside of Michigan, it's not necessarily as well known. But since 1980, our organization was established in 1979. Since 1980, especially, it has been part of the court rule that it was a mandatory process in the life cycle of a tort case. After discovery was completed, you were going to case evaluation. And if you wanted to not go to case evaluation, you basically had to file some sort of motion to opt out. During the last probably 5 years, there were some committees convened, different work groups, feedback from both sides of the V, the plaintiff's bar and the defense bar, and from the neutral community about how they would like to see their cases handled. And one of the outcomes of that was that litigants best know, the counsel for the litigants best know how to handle their case. And that there's a continuum of ADR services that may include case evaluation. It may include arbitration. It may include mediation. It may be med-arb. Bobby's going to talk about that a little bit in a minute. But that parties should be able to decide what was the best platform for their case. So January 1st of 2022 was the largest, most significant change to the case evaluation court rule that we've had. Kyle, I need you to enable the screen sharing for me too, because I've got a screen that I want to share, if that's okay. And so two of the outcomes of that were that case evaluation largely became a voluntary process, that it was no longer mandatory for parties to go to case evaluation. Part of that was the court rule 2.403A that said in substantial part, I've got it in front of me somewhere, that you could and it was in concert with the discovery plan. So, during the time that the discovery rules were expanded in our court rules, that parties filed this discovery plan at the beginning of a court case. And if the discovery plan allowed for ADR forum outside of case evaluation, that the parties could stipulate to that. If the judge agreed with the stipulation, that they would say what ADR process that they were using, the timing of that ADR process in relation to other discovery provisions, and state that, of course, that the ADR process had to be completed no later than 60 days after close of discovery. What was really significant also was that if the court approved this ADR plan and discovery plan with an alternative process, that absent a stipulation from the parties, they could not subsequently be ordered back to case evaluation. So for many years, that was the law of the land, that you were going to case evaluation, and that that was the process that was going to be used. Good afternoon. We've got joining us the Honorable Patricia Frazard. Let me just introduce her quickly for those of you that don't know Judge Frazard. Judge Frazard has served on the Third Judicial Circuit Court since 1999. She was appointed Chief Judge January 1st, 2023. Prior to that, in 2016, she was appointed Presiding Judge of the Court Civil Division. And in 2019, she became Chief Judge Pro Tem of the court. Judge, I'm giving a little background right now on the case evaluation when the rule changed and where we are today. So that's what we're talking about, this whole discovery plan, ADR plan, where parties can, at the onset of the case, they can come to the court and say, this is what forum that we think is best suited for our case. This is what we think will work for us. And if the court signs off on that, then subsequently there's no order later on to go to case evaluation. Another part of this large court rule change under 2.403 was that sanctions were removed. We're going to talk about that a little bit when I walk you through this slide. So with that as the framework, if you can see these stats that I've got up here, I went back from 2011 through 2022. So remember, January 1st of 2022 was when the rule change took effect. So prior to that, you can see our numbers were evaluated, stayed about the same, 5,000, 6,000. There was an uptick in 2017 to 7,000. Significantly, don't forget the pandemic hit us in 2020. So the numbers went down a little bit because there was a period of time that we were trying to get up to speed and roll out online case eval, remote hearings, things of that nature. So they picked up. Then, of course, in 21, you see a bigger uptick. And I think that Bobby can maybe speak to that, but I think that's largely because it was time to move these cases. You know, the pandemic had created this lull where people weren't able to do a lot of discovery. There was some challenges with moving things ahead. And then 21, people were really ready to move cases. So also, if you see significantly this area, this column that says accepted, our settlement, so they compare Wayne County to, they call us the big three, Wayne, Oakland, and Macomb, although that Wayne County is the largest trial court in Michigan and one of the largest in the whole county. I'm going to ask Judge Frazard to speak about that in a minute. I mean, not county, country. I'm going to ask her to speak about that in a minute, the impact on her cases. But you can see the numbers. The high point was 17.9, almost 18%. And the low point was, I think the lowest, we've got a 13.88 was the lowest. But keep in mind, these are, we can only track within that 28-day accept reject period. We're not able to track what happened. Well, we do have settled prior to, you can see those numbers. And but we can't track what happens afterwards because we just don't even have jurisdiction or ownership of the case at that point to know. But I'm going to ask Bobby about this a little later. But it's my understanding that cases, even if they don't accept at that number, if they go on to another ADR process, or at some point they will settle largely, very closely to that number. But so also I want to turn your eye to the 2022. So we're at 17 to 15% acceptance rate. 2022, the first year after the sanctions were removed, we see the acceptance rate drop down to 8%, 8.38% for overall acceptance. In my mind, and I'm going to ask Judge Brizard about this a little later, that means cases are continuing on to the track. I don't know if that means that they're going through some other forum and they're still accepting, but I see a large drop at that point. Also, I ran for 2023 year to date, well, through the end of August. It looks like this, not looks like this acceptance rate has gone in half again. So it went from 8% down to 4.19%. And this is accepting through case eval. And I've got another narrative for you that kind of gives you a pictorial view of these same statistics. So if you just look at where we are now, it looks like we're at 4.19% of cases that are accepting during the case eval period. So with that being said, Judge Brizard, I would like to start with you. We're going to basically talk about start off with this conversation. Wayne County, from my understanding, I know we're it's the largest trial court in Michigan. The caseloads from the judges that you are working with on your civil bench, from what I understand, it's 700 to almost 1,000 cases that they may have at any given time. What's the importance of case eval for your court? And just tell us a little bit about that.
Thank you so much, Lisa. There has been a dramatic change. So let me liken it to the criminal division was unable to try cases for almost 2 years, a year and a half-ish. And so they have a huge backlog. And we had a $3 million grant to try to alleviate that backlog. Because we are able to work largely remotely in civil just by the COVID was not as affected as it was by this issue. So our judges have an average of 1,000 cases at this time and growing, because yes, to quickly to reduce from almost 18% and even lately, 16% before the change to 4% is a dramatic change. To not accept, to have 16% acceptance. And you have to know that it's not just the acceptance rate that affected our court. It's the fact that, what did you say, Lisa? Half the cases, a lot less cases are going to case evaluation at all. And for me to describe how it affects Wayne County Circuit Court, let me start with, we are the 13th busiest court in the nation, by far the busiest court in Michigan, 4.5 times the volume of the next biggest court, Oakland County, and it goes down from there. And so we were hit by this at the mediation tribunal meeting. I remember that it was mentioned that the mediation tribunal and the whole concept came about because of the huge volume of Wayne County. And now it seems that it was ignored, that it was supposed to be, and it was initially exclusive to Wayne County, and it got wiped out by the fact that, for instance, lawyers and mediators thought that, well, maybe we don't need case evaluation, and maybe as a chilling effect on the ability of plaintiffs' attorneys to sustain a case and take it to trial because they have to warn their clients. And asking for a raise of hands during that meeting, I don't think there was one plaintiff's attorney who actually had to pay sanctions in the last 5 years before this occurred, because it's usually negotiated out as no appeal and no sanctions actually paid. But what the sanctions did do is give great teeth to the case evaluation number. And so you had 18% or 16% acceptance rate, where now it would be a policy really of both sides to just wait and see. And again, that's not what hurt us the most, the wait and see attitude and not immediately settling, because one of the reasons why the State Bar ADR committee voted to shut it down is it said that it wasn't very effective because it only had about 15% acceptance rate. Well, acceptance rate is only the date that you have mediation or, case evaluation. But really what it did is it gave a lot of information and a lot of resources for both mediators and judges to settle cases, because the fact that they have to write case evaluation summaries, that they have to get together and see each other, both sides of a case, and meet and try to negotiate, and that there is an initial number put on it, helps most cases. Sure, there's a case where maybe that panel was completely wrong and you kind of have to restart by going back to facilitation. But even then, you have a case evaluation summary and you have the time spent in order to assist a case in getting through the system efficiently. So now we don't have any of that on a good third to a half of cases. And how it affects the courts and the judges' inability to settle cases is that people come with no case evaluation written, even if they got through the system and said they were going to facilitation first. Oftentimes that really didn't happen, or they didn't get a number, or they didn't have a decent summary, so that we don't have very much information. So you're starting from scratch, you're going slowly, and it's much more difficult to get through the system. And so the stories the attorneys are telling me from both sides, plaintiffs and defense, is that they really didn't realize what they were getting into when they were trying to be on the side of non-mandatory case evaluation, that it's costing them more money, it's costing them more time, and it's bogging down the courts so that courts don't have as much time for settlement conferences. What we're doing now is, since most people aren't really ready for their settlement conference, the first one's on Zoom, and the second one, you have to have your clients, and the third one, it has to be in person. And we're touching each case many more times, and it's very inefficient. And that's just the beginning. I mean, we have yet to be able to really get data from our court on how long things are taking, but we're expecting a backlog due wholly to the lack of case evaluation as it was. And also, the last thing I have to say is the mediation tribunal, it would seem to be very difficult to be sustainable. It's so inexpensive and so efficient to have $75 cost to each side, and we have about 18 cases mediated on case evaluated in a day, where up north they might spend the same amount of money, 3 people, and they might case evaluate 1 case. And so now with the reduction of numbers, I would think that it would be difficult to sustain case evaluation. And I don't think any defense attorneys or plaintiffs' attorneys thought that they would want to shut it down completely. They just wanted to pick and choose when they would use it. And it's not realistic when we look at the whole picture.
Thank you, Judge. Bobby, I'm going to turn to you. I think everyone can see the chat. Marty Baum, who is one of the neutral case evaluators for the mediation tribunal, says, and all that for $75, the case eval number is the cornerstone of all settlements. Bobby, I know you've got a statewide personal injury practice, and your thoughts may differ a little, but tell me about your thoughts with this court rule change, and what forum are you choosing, and just where are you at with your practice right now?
You know, I always had a difficult time with the sanctions as a plaintiff's attorney. I don't think it's so much, did my client ever end up paying sanctions? That's not the question I thought was relevant. The relevant question I thought was, how many conversations do we have to have with our plaintiff clients to tell them they don't need to be scared about those sanctions? And then if we're not successful in that conversation, how many acceptances did our clients have when they didn't really like the number, but they just couldn't get over the fact that there may be sanctions despite what we were telling them? So that was my biggest problem with case evaluation. I thought it affected the plaintiffs more than it affected the defense, the insurance company. So that was where I started. And now that we have a change in the actual rule where it's not mandatory, I am sorry that so many cases aren't going to case evaluation, because like the judge said, and like I've always said, case evaluation is a situation where all the parties are brought up to speed, generally for the first time. They get to know their cases, they get to know the other attorneys, they get to talk to their clients, and then they have a number they can talk about. Whether there's acceptance going down, whether there's sanctions or not, I think case evaluation as a whole is very valuable to get the case going. And now, if you don't have case evaluation and you're going to facilitation, and that's the first time that the parties are really getting their hands dirty, an insurance adjuster, it might be the first time they look at a file. Where if you have case evaluation, even if you don't settle on case evaluation, facilitation will now be the second time they're looking at the file. So I think case evaluation is invaluable. I think that the sanctions is a totally separate issue. But unfortunately, now that they've changed it to not be mandatory and that you can opt out with an order, it's basically going to water down the system. And like the judge said, it's certainly going to have a problem with docket control.
Bobby, I've heard from my experience with the bench in Wayne County that it's this belief that, and I think you just touched on this, every time you get attorneys to touch that file gets them closer to settlement. And one of the beauties of case eval was that it was a date certain, that it was on a track, that the mediation tribunal or whatever ADR service, whether it was Oakland County or Macomb County, that they set this date, and the only way you were able to get that adjournment was by, sometimes largely by a motion of the court. That you could, of course, you can't just call us and say adjourn the case. Either you stipulate to it or the judge allows that. Now with facilitation, mediation, people can get their own adjournment. So Judge Broussard, let me turn back to you. Are you seeing parties showing up in your courtroom at this point that at the first status conference that haven't even talked before or had their ADR processed, or what are you seeing at this point?
Yes, just the other day, there was a bench meeting, and right after that, a meeting of the judicial attorneys. And at both meetings, it was noted that there's a great change in preparation for settlement conferences. So courts have a very short amount of time. I'm sorry.
Thank you.
I'm sorry, I have a bad cold.
That's
but
okay. That's okay.
So we have approximately, 15 minutes to a half hour to be able to handle a settlement conference. And it's impossible to really get all done without a preliminary number and preliminary meetings.
Okay, Bobby, let me turn to you real quick so that the judge can get something to drink. How do you, what's the thought process at this point now? What do you choose? Do you do facilitation? Are you going to a case eval, or is it a case by case basis, or what's your thought process?
I very rarely agree to opt out of case evaluation for the reasons I mentioned earlier. Before this rule went into place, facilitation was becoming the norm, but you also had the case evaluation. So kind of the double dip effect I like on most cases. Every once in a while, there's a particular situation where I think it'll be a waste of time, but that's the minority of cases. One quick story that makes my point. I had a case in Virginia, a really bad injury case in Virginia, and I never had a case in Virginia before. They don't have case evaluation. Okay. And this case went on for probably a year longer than it would have because there was no case evaluation, because they kept on pushing a mediation back to the point where we were up against trial, and that's the only reason they agreed to do it. It eventually resolved on a mediation when it could have very easily resolved or gotten on a faster track with case evaluation. And that really showed me that the situation with case evaluation helps you resolve cases. It just does. So I choose to mostly case evaluate if I can. And again, they're going to go to facilitation more often than not anyway.
So I agree absolutely with Bobby on that. And in the courtrooms, the effect is that the judges initially were trying to go with what the attorneys wanted. So if the attorneys opt out of case evaluation, the judges allowed them to opt out. And if they wanted case evaluation, the judges would go with that. But unfortunately, when it came to the courtrooms, the judges realized that most of those who opted out were not prepared. They either didn't go to facilitation at all, or if they went, they still they still had much less information, much less cooperation and meeting with each other. And so they were a case that was impossible for the judge to do very much with. So a lot of the judges are going back and being requiring that the criteria to meet the opt-out was met. And in a lot of cases, it really wasn't even met. The lawyers don't even look at it, understand it. They just say, we opt out. So the judges were taking their little cheat sheet that Lisa gave them on what the requirements are and saying, well, this one wasn't met and this one wasn't met, so no, you're not opting out. And, so the lawyers, because of the way the cases are being handled, are, it's I guess increasing a little bit, and it's going to increase more temporarily, that the judges are going to make those requirements mandatory, but then people will be meeting those requirements eventually, right, when they're used to them and meeting them. And it's still going in the wrong direction. It's going in the direction of not allowing the mediation tribunal to really be pragmatically sustainable. If you don't have enough cases going through, then you're not profitable and can't work. But another thing that the mediation tribunal has done is to fund our Discovery Master program, which also makes our court very efficient, in that I don't know if it costs about $50,000 a year to run the Discovery Master program. But as lawyers, when you come into a Wayne County Circuit Court on Friday, you have to wait a lot less if all of those who are arguing about how many interrogatories have been answered can go meet with a Discovery Master for a few minutes and then come back, and you don't have to take up a lot of motion day time on minor discovery issues. So the mediation tribunal funded a grant for 2 retired judges to come in every Friday 8:30 to 12:30 and have an extra resource for attorneys to go to before they come into the courtroom. And that is at no cost to the attorneys. So the statement of all that for $75, there's even a bonus to that. So it's and I was interested to note that Bobby said that it's that you have to talk to your clients about what the real situation is. That's really interesting, because it was used. I hear and saw that it was that the supposed chilling effect on the plaintiffs to take cases into the system was argued against case evaluation, to shut down case evaluation with sanctions. So the sanctions, the real effect of sanctions and how it works was not really noted. It was as if there was a real threat and yesterday or the day before, when we were at the Detroit Bar ADR section, Lisa, remember Justice Wilder had said that the Supreme Court works on data. Well, I didn't see any data that actually showed that had a chilling effect on plaintiffs' attorneys, and plaintiffs' litigants going through the system. The reality of the situation is this shutdown of case evaluation is going to have a chilling effect, because we can only try so many cases, and the cost and efficiency for plaintiffs' attorneys and for plaintiffs to go through the system is going to be much more difficult without the benefit of that really important tool and resource of case evaluation. And so if it's gone, Wayne County Circuit Court will be bogged down like it was before case evaluation came about.
Thank you. Wayne County is definitely unique in the volume of the cases that are filed there. Bobby, I'm going to turn to you. We've got a couple comments in the chat about stipping the numbers. Paula Cole sits as a defense case evaluator. She's a former attorney with the city of Detroit. And she says that she finds when she sits, the majority of people agree to a number, especially in the no-fault provider suits. Jessica Buck is a current defense litigator, and she agrees with Paula. She says she hears them say there's no sanctions anymore, so it really doesn't matter. She's wondering, do they put a lot of thought into this number that they're agreeing to? So Bobby, let me ask you that. You have cases at case eval and you sit as a case evaluator. What are your thoughts about sticking to this number, especially as far as moving the settlement needle forward? And talk to me about if you go to facilitation after, so it's a compound question. I know you're not supposed to do this in law, but what's the thought behind sticking to this number and for moving the needle for settlement? And if you go to facilitation later, does that lock you into that number that you've stepped to? Talk to me about that.
In Wayne County, when you sit, a majority of your cases are either traditional no-fault cases or the provider cases. And on most of those cases these days, we're seeing younger attorneys sent to case evaluation. And in most of those cases, we're seeing younger attorneys that haven't looked at the file very closely. And so forcing them to talk at case evaluation, forcing them to see if they can come up with a number, unfortunately, is in many instances the first time they are going to learn their file and perhaps come to some type of resolution. But either way, if case evaluation didn't exist, that would be happening perhaps at a facilitation. And if it doesn't get resolved at facilitation, the next step isn't another facilitation. It's going to see Judge Frizard in a settlement conference, when ordinarily, if they had gone through a case evaluation that didn't settle, they might have a better chance of settling a facilitation, and it kind of weeds through the system. So yes, I think it's invaluable for that reason alone. When you see these cases come up and you're telling the litigants, have you guys talked? If you haven't talked, can you talk? Can you try to come up with a number or at least get closer to help us? And we do it in every case that we evaluate, and it's generally successful, whether it's that day or in the days that follow.
Okay, thank you, Bobby. Judge Frizard, there's a question from Joe Basta in the chat about, is the need for docket control likely to result in the imposition something like the pilot program? So you were spearheaded this pilot program for cases that evaluated at 25,000 or less. We call it the mandatory 25K program. It's no longer a pilot at this point. It is a local administrative order. And just to give some background for the people listening, years ago, if a case, the jurisdictional limit for being in circuit court is 25,000. And years ago, if the case evaluated at that amount or under, there was an automatic remand to the district court. Instead of doing that, the remand is also an option now to the litigants, but another not an option. What will happen if you choose, if it doesn't accept or during the 28-day reject period, the acceptance period, the court will order it to mandatory mediation. And we have a list of general civil trained mediators that come in, and there's another touch point to follow up at that. So two things again, would you speak a little bit about that process in case people are new to it? Joe is referring to that, but also I also hear him saying, is the court considering or contemplating some sort of carve out similar to that to deal with the case evaluation gap that's being that you're seeing? You're on mute, Judge.
Yes, that's a good point. We do have the under $25,000 program, but again, that program is identified. I did start it, and it's identified and implemented by the mediation tribunal. So if you didn't have a mediation tribunal, then how do you implement the program? Because the court can't, the court doesn't identify it by itself. Again, the resources, the monies paid by attorneys to have case evaluation and late fees support all of these things. And they have supported and identified and made available low cost mediation for those under 25,000 by its program itself. So to lose mediation would be to lose that program. We are also going to the Supreme Court. We're looking for a carve out for sure. We need that carve out. It wasn't, it seems to be that who whoever decided that this was a good idea completely disregarded Wayne County and the amount of work that Wayne County really does. And one of the things that we have to ask for at this time is to have the $25,000 minimum case that goes to circuit court to be increased to $50,000, because there's no way that we can really increase the time it takes and the number of and the work that goes into it without that. So it's interesting. The next question is, I hate the loss of sanctions, but hasn't this led to more mediation settlements? Isn't there a much higher success rate for mediation? Bobby pointed out the last time he spoke that it's really a 2-point process. It's not a lot of cases, even low-level auto neg cases, go to case evaluation. It's very early, a very inexpensive number and work. So it cost attorneys, again, a lot less, and litigants a lot less to go through the system when you have a very early process that you go to case evaluation for $75 each, you get a number, you have a case evaluation summary, and you talk to each other. Then it costs less to go to mediation, because instead of being a 6-hour mediation, it could be a 2-hour mediation on a lower level case. And then you go to your court, and if somehow you didn't settle at facilitation, by the time you go to your court, maybe someone has a client that they need the judge to give them the reality of what risk you're taking at trial, or there are some other issues, maybe they're waiting for some numbers, but it gets settled. So do most cases still get settled? Absolutely. You're still probably going to have at least a 90% settlement rate for cases, but it's going to take a lot longer at a lot higher cost. And the cases that are going to trial they're not going to go to trial as quickly, because it takes a lot longer to figure out which cases need to go to trial and which don't. So it's very costly for everyone involved.
Thank you, Bobby. That kind of segues into the question from Cynthia Geller that does defense work. And Cynthia's pointing out many attorneys representing providers don't know the amount of bills that they're claiming, rendering case evaluation process useless. What are your thoughts on where case eval falls in the discovery process, right at the end of it? Or what are your thoughts on where it is, and maybe from a plaintiff's perspective, where you would like to see an ADR form actually fall, where you might have more of a toothsome case at that point?
Well, my first thought when I saw Cynthia's comment was just that. I agree with her on the first part. A lot of young attorneys come and they don't know what case they have. But I don't agree with her at all on the second part. It's certainly not useless. If anything, it's bringing those young attorneys up to speed on the fact that get to know your file, because we are going to give you a number and you're going to have to go back and talk to your clients now about that number. And if you don't think it's a good number, you're going to have to find out why. Therefore, you're going to have to learn your file. And if they don't settle on that, at least they've gotten down the field, so to speak, on their cases. And if they do go to facilitation, it's more meaningful. So I think it's fine where it is as far as within the discovery process. It's generally at the end of the discovery process. And if they don't know their file, shame on them. But without case evaluation, that whole discovering their file, learning their file, being brought up to speed happens months later, whether it's at a facilitation or a settlement conference. So I think that's even more reason you have case evaluation. You just, aren't going to get cases settled necessarily on case evaluation, but it helps.
Okay. Well, Bobby, let me stay with you then. We've got about 10 minutes left. So walk us through, you're going to case eval. What are best practices? How do you make it effective? Like, how do you prepare for it? Prepare your client? What do you do during the hearing? Give us some pointers.
One of the things that has bothered me ever since I can remember with what's happening at case evaluation is the fact that people aren't preparing before the case evaluation. I pick up the phone all the time. If I think that I'm going to case evaluation on a case and I'm not going to be prepared, I'm going to be embarrassed, right? So I think when you have case evaluation, it is your opportunity to get to know the file, get to know your opponent, get to know whether you have a chance of settling on case evaluation, picking up the phone and calling. And if you haven't done all that, the good case evaluators are going to tell you, go in a room and talk about your case. You know your case better than we do. Give us some guidance, whether it's a number or give us some guidance because you're going to get some issues out of the equation. So, I always talk to my client before case evaluation. I explain the process to them. I explain what it's all about. And again, I try to prepare myself to not necessarily even resolve the case at case evaluation, but at least have a preparation that allows me to further on down the line settle the case. So that's how I view it. And if it's taken out of the process, that whole thing is just going to, again, it's going to be longer down the road that you're doing all that.
But let me stay with you a few more other questions, Bobby. During the hearing, what's the importance of, and I know this from being the ADR clerk and the executive director, what about filing these summaries? A summary is supposed to be a brief summary. If you're filing something that's 200 pages, are the case evaluators going to read it? What's best practice for filing these summaries? Talk to us a little bit about that.
One of the things I did at my old firm where I was for 29 years was I went with the model that we started with in the early 90s. And that was do a summary of the summary up front.
Okay.
Kind of list all the basic facts of the case, who the parties are, what kind of policy there are, what the injuries are, that type of thing. And then just go through very specifically some of the injuries and the treatment. And then if you want to put your 10 pages after that, because what we found were that the case evaluators are going to read, if it's right up front, 1 or 2 pages, and then they're going to know the case in general, even if they don't read the rest. These summaries that we sometimes get that are just stories, and they start out in the beginning and they just keep on going and going and going. I mean, when I read the summaries, I go through each one first and I see what kind of case it is and what's involved. Then I go back and I read the summaries, and those booklets, we don't read those. We're not going to spend a half hour on one case to read a summary like that. So I would say short to the point, put your important points up front. And if you want to summarize because you want to put together a lot of language, so to speak, do a summary in the beginning.
Judge Fazzard, let me turn to you. I'm not sure if you're aware of this, but a lot of parties will show up at case eval and say, oh, we've got an SD motion pending, and this, we don't really need to evaluate this, or they'll even ask that we remove it from the panel because there's an MSD coming. What are your thoughts on that? We keep saying that, you don't know what's going to happen. And as the administrator, my thought would be that you need to come in with the thought that if it survives the MSD, if this case still stays on this court's docket, you need to have a number. So what are your thoughts on people coming in with that mindset?
Well, that's exactly right. They shouldn't be wasting the case evaluator panel time by arguing their summary disposition motion, which I hear that they do sometime to weigh the, whether that would be granted, the summary disposition would be granted or not. I mean, that's an issue of law that has to be decided by a judge, and it should have no effect whatsoever on the value of the case. The value of the case should be done separately, and the case evaluators should not be considering the viability of the motion in any way. And the courts don't really appreciate if that gets done anyway. I mean, there might be some push, well, our case evaluators thought you should grant this. No, it's a waste of everybody's time. We have to look at the facts of the case and the law and what to do with that case. But it certainly is no reason to skip case evaluation, and it should be no factor in the case evaluation number.
Okay. Judge, let me stay with you then at this settlement conference. So, well, before you even get to the settlement conference, on your order for the case evaluation order for the tracks of the case, some of your colleagues on the bench I'm seeing do 2 things at one time. They will place they will allow the parties for facilitation. So, for example, October 1st is your facilitation date. And then they hard code in a case eval date that they want to see that 30 days later. And that comes out on the case evaluation, the scheduling order. And so what happens is it gives them time to go to facilitation. But if it doesn't settle at facilitation, that case eval date is already noticed and it's already set out there, but they have time to cancel it without fees if it resolves. What are your thoughts? Do you think that's a good practice from the bench or for attorneys to keep in mind to automatically have these two dates out there? Like I said, stop thinking of one and done. Think about this, that this is going to be a fluid process and that there may be a need for having more than one ADR forum. And before they come back to your honor and say, we haven't touched it, we haven't talked. So what are your thoughts on that?
The optimal process would involve, first of all, I see this question, vast majority of courts outside of metro area would not case evaluate until after discovery. I mean, our scheduling order is that way. I mean, the best method would be to have discovery when the two attorneys, the two sides are efficient, to have discovery done very promptly, and to have case evaluation first and immediately after discovery date is closed, and then to have a date already set for a facilitation. And really, I wish the facilitators, there's a lot of mediators that fought for, closing down case evaluation, thinking that, it takes up some of their work. No, it makes their work easier and more efficient. So they should have a date. I love that 3-step process. Okay. Have discovery, close discovery, then immediately go to case evaluation, a quick number, inexpensive number, $75 each with a summary. So you're doing some work on the case. And then you have already a facilitation date set, so that you can cancel it if you do accept. But if not, you have a facilitation date set soon after with each other. That would be a process where the attorneys, of course, have to agree to the facilitator. So they would have to be involved in it, pick a facilitator, but the date could be set in the process. And then a short time after that date, you go to the court. So the court would be add efficiency to the court's process, because the court would only get cases that couldn't be settled at both case evaluation and the facilitation. So that would be great.
Thank you. We have a couple minutes to close out, but Timothy Brady has just been able to join us. He's had horrible internet connectivity issues. And Tim, I'm glad you were here. So take us home, Tim. How important is case eval to your practice? Tim is from the defense bar. He does personal injury cases, defense personal injury cases, and he's currently president of Michigan Defense Trial Council. How important is case eval to you and your clients?
Absolutely imperative, and thank you. And I apologize for the delay. I was at a funeral and there was not any service. What I would like to, something I've been realizing lately is a lot of, on PIP stuff on providers whose people are asking, well, do you want to remove and go to facilitation? For an efficiency standpoint and from a client standpoint, that doesn't really make sense. I mean, we're paying $75 versus $1,000 for cases that could be worth $1,000 themselves. And what we've done, at least in Wayne County, is we've really worked hard to pare down our list. So it's people that know the law, that know and can apply the law, and so forth. So, that's something that I think is imperative. It's people that know PIP, or we have employment panels, or we have commercial panels. And these are the way that we're able to make everything more efficient. But I think that keeping this process is imperative. I use it very seriously to try to resolve cases.
Cynthia Geller said, please reiterate your comment about the use of no meat. I think you talked about this at our annual.
Yeah. Well,
what does that mean, Tim?
We had our annual meeting for Mediation Tribunal, and I made a joke that no meat has not been around since 2002. And I guess I said that the older lawyers are training their attorneys well, but it doesn't exist anymore. So one thing that we've changed in Wayne County is that we're trying to avoid the use of non-unanimous awards unless actually people aren't agreeing, or if there's a good reason, such as a priority dispute or something along those lines. But yeah, we try to avoid no meat, other, just, oh, we want to do adjourn, but we don't have time. I mean, it's a real process. And I remember how Caseville has changed. I mean, I wouldn't imagine showing up at Caseville without a suit and tie on. I mean, things have changed, and that's fine. But I think people should be prepared and be, and the evaluators to actually evaluate. So in terms of a not no mead, which we now is kind of non-unanimous, I believe that the non-unanimous should only be used if there actually is a disagreement between the plaintiff and the defense and the neutral can't agree on a number, or if there's a legitimate reason, now like a priority dispute or a question of law. But other than that, I think that the panels should work to put numbers on it and do their best that way.
I'd like to thank my panel. I've got Tim Brady, Judge Patricia Frizard, and Bobby Raitt, and I will turn it over to Jennifer Grieco at this point. Thank you.
Thank you so much, Lisa. That was an excellent discussion. As always, you wish you could keep going in these discussions. 50 minutes is a short period of time. My name is Jennifer Grieco, and I'm the chair of the ADR section. I want to thank these presenters, and all of the presentations in our day and a half were excellent. If there is any presentation that you wanted to attend but you were unable to do so because of the 2-track or because of your schedule, please know that all of these are going to be uploaded on the ADR section's webpage shortly in the near future, and so you will be able to view anything you want to view. I know there were a number that I wanted to see as well. I hope everyone who attended found the conference rewarding, that you learned a few things to assist you with your ADR practice. And I just have a couple announcements before we conclude, if you can just hang in there for a few minutes. The first is to complete the survey that you're going to receive when we sign off. You will need to complete the survey in order to obtain the certificate for the 11 hours of advanced mediation training credits. And yes, the materials will be available. There is also an important question in the survey regarding whether you prefer the conference virtual or in person. The committee planning next year's conference will take your preferences into consideration when planning the 2024 conference. So please share your thoughts. And if there's a person, again, who misses the networking aspect of being in person, as I do, I encourage you to sign up to attend our annual awards dinner on October 24th at St. John's Resort in Plymouth. Cocktails will start at 5:30. There's going to be time to network both before, during, and after the awards dinner, and you can congratulate all of the deserving award winners. I want to thank all of the presenters for their hard work and willingness to volunteer their time to teach attendees advanced skills in mediation and arbitration. It was an amazing conference because they shared their talents and their expertise. If there's someone you want to hear more from in the future, like a future Lunch and Learn or one of our conferences or seminars, please let us know that in the survey, and the Skills Committee Action Team will take that into consideration. I want to thank this year's Planning Committee. Zena Zumeta, Nikisha Cheney, Michael Lieb, Alex Green, Larry Saylor, Ed Pappas, and Bob Wright. They met almost every month for the last year to put this together. And of course, I have to thank our administrator, Marianne Parks, the person who makes this conference and the section run smoothly. We could not do anything without her. I want to thank Kyle Jordan at Tribe. Not only does the team at Tribe do an excellent job of creating an easy-to-use platform and assist all of our presenters and attendees to use the platform, but Kyle is just a pleasure to work with. Finally, I want to thank all of our sponsors. They allow us to keep the costs lower for the conference and for the awards dinner. And those sponsors are Widgeon Dispute Resolution, Dickinson Wright, Mediation Tribunal Association, Lee Hornberger, Altier Law, Lewis and Munday, JAMS, Stevens Legal Solutions, Kitch, Lieb ADR, Marie Walker PLLC, American Settlement Centers, Kabliska Law Mediation, Sheldon J. Stark Mediation, and Arbitrator, Miller Canfield, Preemy, and Abbott Nicholson, William Gilbride. Again, thank you to all of our sponsors. We couldn't do this without you. And thank you, each of you, for attending. That concludes the 2023 ADR Annual Conference. We look forward to seeing you at the awards dinner, and I hope you enjoy the rest of the weekend. Thank you.